Good afternoon, everyone. I can tell that this is a hardcore group of patent interested because this is a very nice afternoon, but you're here and we're so glad that you're here. So thanks for joining us for WARF Essential Topics. My name is Laura Heisler and I am Director of Programming for the Wisconsin Alumni Research Foundation. Before I give a few words of background on today's star-studded assemblage of patent experts, let me just offer a few housekeeping notes for today's session. How many of you have been to a WARF Essential Topics in the past? So some of you, but not all of you. So I will mention that what we're going to do is we're going to have a bit of introductory remarks, and then we're going to have a facilitated discussion with our panelists, and then we will open things up for some audience Q&A. We videotape all of these, and we maintain a video library on the WARF website. So I'm going to ask you, if you do have a question, to raise your hand, and a person with a mic will run and catch your question. But if you could wait for the mic, that will help us faithfully record your question on the video. So that would be great. If you ever do want to look at previous sessions, they're all there on the WARF website on warf.org underneath programs. I also want to mention that it is our custom at the end of the hour, and this will conclude right around 5, to invite all of you to join for an informal networking reception in the atrium right behind you. The walls behind you will rise up, and you are welcome to join us for food and beverage and further discussion with today's speakers. Now with that, I'd like to take a moment to introduce the amazing group of experts we have, and they truly, each of them are nationally known and extremely distinguished. So I will start with in alphabetical order of our two panelists. Kevin Noonan is a partner with the firm of McDonald, Bain, Hulbert, and Berghoff, LLP. His practice involves all aspects of patent prosecution and litigation. He focuses in biotechnology. He represents universities as well as pharmaceutical companies, large and small, on myriad issues related to patenting and licensing. He has also filed amicus briefs to district courts, the Federal Circuit, and the U.S. Supreme Court involving patenting issues relevant to biotechnology. And he has authored amicus curiae briefs in landmark patent and other cases in the U.S. Court of Appeals and the U.S. Supreme Court. He is a frequent speaker, commentator, and author on a variety of intellectual property law topics. And 6 years ago this month, in 2010, he was interviewed for a segment that aired on 60 Minutes that addressed the issue of gene patenting, so relevant to today's subject. And so we'll see if today's moderator can give Morley Safer a run for his money in terms of talking to Dr. Noonan. We are also honored to be joined by Dr. Crystal Shepard, who is the director of the Elijah McCoy U.S. Patent and Trademark Office, that is the Midwest Regional Branch of the USPTO. And Crystal Shepard joined the USPTO in 2015 as director of that regional office. Prior to joining the USPTO, she was an assistant professor of law at the University of Nebraska, where she co-founded a program of concentrated study in IP law at the Law College. She has an MS and a PhD in cellular and molecular biology from University of Michigan and a JD from Cornell University. She has over 2 decades of science, intellectual property law, and policy experience, including as a practicing attorney at Foley & Lardner and the U.S. International Trade Commission, and internships with Judge Rader at the U.S. Court of Appeals for the Federal Circuit and the Executive Office of the President's Office of Science and Technology Policy. Her successful career in IP law and policy includes her tenure as Chief Counsel on Patents and Trademarks for the U.S. House of Representatives Committee on the Judiciary, where she was integral in many endeavors leading to the Leahy-Smith America Invents Act. And then finally, moderating today's session is our own Michael Falk, General Counsel for Wharf. Michael joined Wharf in 1999 and became General Counsel in 2007 after having served as both the licensing manager and director of Wharf's IP department. In his current role, he oversees all legal activities associated with the intake, management, licensing, and enforcement of Wharf's extensive patent portfolio of more than 1,500 active patented technologies. He earned his BA at Columbia and holds multiple degrees from UW-Madison, including a master's in bacteriology, MBA, and a JD. Prior to joining Wharf, he worked in private practice at Foley & Lardner and focused on patent litigation and corporate contracts, and is also an adjunct professor in the School of Medicine and Public Health. So with that, I'd like to invite our moderator and our 2 panelists to come on up. Thank you.
Thank you, Laura. Hello, everyone. great credit to this crew here. They squirmed during their introductions. They're both such modest people. They kept saying, "You can stop talking about me now." But they are very impressive people, and we started to take it for granted that we get a USPTO director to come visit with us like this, because Crystal's been so generous with her time. So it really is a special privilege we have, and I think it speaks to the fact that Wharf and the University of Wisconsin are so respected that we're able to do that. So appreciate you being here. I'm going to give a little introduction just to kind of put us in context, and I have this chart here which you don't have to look at, but I was reviewing the last 10 years of changes to the patent law, and we're going to talk today about subject matter 101 questions, but there's been so many. The moderator, the panelists and I promised we wouldn't just cite case names and then, one phrase descriptions of them. We try to be more inclusive and explain our background. But for this introduction, I am going to do that. We had the KSR decision on obviousness, of course. We had eBay on injunctions. We had MedImmune on declaratory judgment actions. Nautilus on indefiniteness. We had a bunch of patent term fights that always include the name of the patent office director and then a company. We had, of course, the American Invents Act, which changed the statute. So it's been a really tumultuous 10 years to practice patent law or to be an inventor who's trying to get technology patented by the patent office. And then subject matter 101, the section of the statute, came into play. And that's one that most of us, I took a quote here from a textbook as I was preparing for my talk today, and it said, quotes the statute and talks about how it's any new and useful process, and then says, this broad general rule is subject to well-established exceptions that preclude patenting laws of nature, natural phenomena, and abstract ideas. Of course, those well-established norms are in question now, and that's what we're going to talk about today, especially with an eye to our startup community and our inventor community to talk about not only, oh, isn't that an interesting question, the law's changing, but what can we do about it? What are practical steps you can take, and sort of what is the patent office? What are the courts? What is Congress considering? And then sort of what does that all mean as you're trying to file your patents on a day-to-day basis? We had the former director of the USPTO, David Kapos, come out last week and say that we should abolish 101. Now he's not a shrinking violet, so he does say a lot of things like that. He's not afraid to put it out there, but it's a real interesting state of affairs we're in, where we have a former director of the Patent Office saying we should just get rid of this section of the statute because it's too confusing or not serving the purpose that was originally intended. I've got in front of me, just as I look at this, I talked to our intellectual property team about some of the concerns we've heard from campus investigators as they've tried to deal with this issue. And I've got examples here from our stem cell community where they're having difficulty prosecuting patents or getting caught up in appeal. Natural products, of course, examples from pharmacy and microbial sciences. Examples, Beth Werner pointed out that Hector DeLuca's original work, and Hector DeLuca, of course, is known for his vitamin D work. His original work and many of the inventions he made were actually naturally derived vitamin D molecules. And so in this day and age, we would expect those to be rejected. Biomarkers, that's another area where we see, I've got examples here from someone working in traumatic brain injury, someone working in mitochondrial disease. We see a lot of different areas where people are making important discoveries related to biomarkers, and certainly as we imagine the world of personalized medicine, those will be important, but having trouble getting through the patent office. In certain instances, Wharf's even declining to patent because we just know the kind of fight that's ahead of us. So it's really put a lot in flux on campus, and we hear a lot from our investigator community about, so what do we do? Should we even bother disclosing? If we do, how are we going to get through these patent office fights? Is the law going to change? And that's in part why we've got our panelists here today. So I think with that, I will turn it over. And I think, Crystal, you're going to start and kind of maybe from the patent office perspective and take us from there.
Yeah, because I have to use the slides, I'm going to move over here so I can actually see them. I wanted to thank you for providing such wonderful weather today where I get to stay inside. Okay, so I'm going to take a couple steps back because I know you're, bench scientists and some of the more nuances, you don't want to know the very detailed nuances. That's what you have Wharf for. You kind of want an overview because you're thinking to yourself, I keep hearing all these things about software not being patentable and natural products aren't patentable. Is any of that true? So I'm going to tell you a little bit about where the Patent and Trademark Office is on this, and hopefully we can have more of a discussion later. I'm just starting my stopwatch here because I also teach, and most of you teach also, or some of you teach. And as a law professor, I can talk forever about minutia, but I won't today. Okay, so let's start here. Okay, but is it patentable? And this is a really complicated question, but we're going to kind of touch the surface of it because that's what you're concerned about. But I will say first off is, if someone's telling you the sky is falling and that the entire economic system of the United States is going to go kaput because of these Supreme Court decisions, the United States Patent and Trademark Office has been there for 226 years this year. And about every 30 or 40 years, someone says the sky is falling, it's going to tank the entire United States economy. There's a lot of history here, because think about it, everything that's ever been patented, the light bulb, the silliest thing you can think of. Well, like I was going to say peanut butter and jelly sandwiches, but we did patent that, and then we came back. I said, no, we shouldn't have patented that. And has gone through either a piece of paper or electronically to the United States Patent and Trademark Office. So we have our own sets of procedures, protocols that we go through. What we follow, actually, the law, comes from Congress, and it comes from the Supreme Court. So the Congress has a statute called 101. It's what you keep hearing about, subject matter 101. So that's a very short thing about subject matter. The courts, however, expanded upon that to put some meat on the bones to what that means. And at one point they expanded upon it, and then they kind of started to contract it. And we're in a time and place of contraction. It's happened throughout our history, and this is another time of potential contraction. So some of the cases you may have heard about, the one that most people in software are concerned about, well, there's Alice, there's Myriad, and Mayo. And what the USPTO does is when the Supreme Court comes out with a decision that's different from what we have been doing, we put together what's called Interim Guidelines. So if you pick this up from outside, this is a very short flow chart of our Interim Guidelines, how we review whether or not what you submit is patentable under Section 101. And remember, Section 101 is just one section of many in the statute. So just because you can make it under 101 doesn't mean you're going to make it under 102, 103, or 112. So 101, the courts have been really playing a lot in this area. So we have, in our interim guidance, this is just one page of several pages of guidance that if you want to go online and find it, it's helpful. We have examples based on real cases, and some are hypotheticals. And everything we've used to train our examiners is online for you to review. We're not hiding any balls. Everything is transparent. So these are the cases you may have heard of, and I'm not going to spend much time talking about them. Bilski, Mayo, Myriad, Alice Corp. There's some others, another one called Sequinome that's in play right now, but there's no Supreme Court decision on that one yet. So when Bilski came out, Bilski really went to what's called abstract ideas. So those of you who are working in code, with code and computer programming, that's the one that's one of the ones that's interesting to you. Bilski and then Alice at the 4 years later. For those of you who are working in bio or maybe even chemistry and some other things, the Mayo decision and the Myriad decision are the ones that you're going to be concerned about. The Mayo and Myriad and now Sequinome all deal with aspects of figuring out when there's a product of nature, when is that patentable? And if you see these words, abstract idea, law of nature, product of nature, there's also natural phenomena, those are all come from the courts. So who defines what those means? We don't define what that means, PTO. The courts define what those mean. So we're in a process right now of figuring out, because from the courts, what they mean by these things. And that's where the confusion comes in. We have to, however, in the meantime, even though we're waiting for more guidance, we have to continue issuing patents. We have to continue along the way. So here's just what you have in front of you, some of you. And this is the eligibility guidelines. It comes from the Mayo test and from other pieces of case law that we have. So if you start at the top, the easiest part, it comes actually directly from section 101 in the law, is a claim to a process, machine, manufacture, or composition of matter. When I teach my students, I challenge them by saying, can you tell me of anything that is not a process, machine, manufacture, or composition of matter? Everything is composed of matter. That is the group that says, if it's in there, then we can go forward under 101. The court has said in some occasions that there are things that don't fall under 101, and you can find those in the more detailed notes in our analysis. After that, here's the part where it starts becoming more tricky. So part 1 of the Mayo test is a claim, meaning is your invention, that as you've described it, directed to a law of nature, a natural phenomena, or an abstract idea. Those are those judicially recognized exceptions that are causing problems. Those were there 10 years ago, 15 years ago. I mean, they've been there for a while. They become a problem recently only because the way we have been using those at the USPTO has changed because of the Supreme Court telling us what we've done wrong and figuring out what those things mean and what should be patentable and what should not be patentable. The good news about this is that Section 2A, even if you are a law of nature, a natural phenomena, or an abstract idea, so code or vitamin D, you can still, that does not mean you're not patentable. People keep saying software is not patentable. That's not true. You have to go to step 2. Step 2 says, even if it falls into one of those categories of abstract idea, natural phenomena, or law of nature, does it add something significantly more than just the abstract idea, law of nature, or physical phenomena? So there are many things that may fall into the law of nature and perhaps the vitamin D that a court or the USPTO may find add something significantly more than just the wild type nature. I'm a molecular biologist, so I'm saying wild type. You engineers, whatever you would say. Other than the wild type one. The question is, how broad is that going to be? We're only going to find that out through us granting patents or denying patents, and then the court saying this is too far or this is not far enough. We're in a time of transition. I understand that this creates uncertainty, but that in no way means that code is not patentable and that biological products are not patentable. It's whether or not you fit it, whether or not in step 2B you can show something significantly more. I'm going to go back just briefly to laws of nature. Under law of the nature, there's laws of nature, there's another way to get out of that. So I'm going to go back to this slide. Oops, it's actually going forward. Under the myriad. So myriad was genes. Just think DNA for those of you, again, engineers, genes. In that case, it was a piece of DNA that had been cut and that sort of, it had been cut and taken out of the chromosome, amplified and all of that. The court said the gene is not patentable. Law of nature, however, the way that we've looked through the case law and the way that we the way we're currently reviewing these cases is, and it says on the bottom, is it markedly different than the wild type? So in case of the vitamin D, and I'm not saying this is true or not, I'm just saying in case of vitamin D, if it was markedly different, there's possibility that it could be found to be patentable despite being a law of nature or product of nature. And lastly, I'm almost done with my 10 minutes here. But you don't need to go into this much depth. Your Wharf will go into this depth for you. That's why you look to them. But there's lots of materials for them to go through to try and figure out, okay, we have these examples and these examples. Is what you're doing closer to this example, or is it closer to that example? And if so, let's write it in a way that looks better, more like that example. So I'm going to end there, but Professor Newton, I'm sorry, Attorney Noonan may say something different, but I want to say again that code and products of nature are not de facto unpatentable.
Ready up? You ready to go, Kevin?
It's always good to hear hopeful things from the Patent Office. I have a great deal of respect and also condolence for everyone at the office because they've been given a tough job. All right, I'm going to step back a little bit and kind of try to give you at least some of the why. Why does the Supreme Court care? Well, one of the things about patenting is that it's what's called an enumerated power of Congress. It's actually in the Constitution. One of the things Congress was expressly allowed to do, and there's not that many of them, declare war, for example, is another one, but Congress is permitted to grant patents. And so why did the founders think that was a good idea, besides the fact that Thomas Jefferson was one of them? The reason that they thought it was a good idea was, it's funny because it's kind of paradoxical, it's not for inventors, it's for the rest of us. Because if you think about the way things were done in England in the Middle Ages and later, the idea of keeping something a secret, to have a guild to make sure that only the people who'd been initiated and inducted would know how to do the to make the magic sauce, the special sauce at McDonald's, or make Coca-Cola or things of that nature. You wanted people to keep that secret. Well, that's not really good for the rest of us. And the reason the founders recognized that what you want to do is incentivize people to disclose. And so they said that writers and inventors would have rights in their writings and their inventions for a limited amount of time, okay, but they'd have exclusive rights. And so the whole purpose was to get that disclosure. Now, the reason that I think, all due respect for David Kapos, that if Congress struck down Section 101 tomorrow, that it wouldn't matter to the Supreme Court, is that their job is to make sure Congress doesn't go outside the boundaries that the Constitution sets for what Congress is permitted to do. And the reason in the Constitution for being able to grant patents was to promote progress. And that's what the Supreme Court is concerned about. And Justice Breyer has said this expressly, and although I disagree with his opinion on it, the fact of the matter is he believes that it's kind of like Goldilocks. There can be too much patenting and too little patenting. That if you don't permit any patenting, you're not going to give people the incentive to invent. As an aside, people will always have the incentive to invent. The question is, what are they going to do with it? Secondly, if you have too much patenting, that you'll inhibit innovation. And that's where these three thou shalt nots that the Supreme Court has come up with, come from. So a law of nature, and they always cite E equals MC squared or Archimedes' principle, or it really wasn't a product of nature. That was only in the Supreme Court for the first time in Myriad. There were lower courts that talked about natural products, but natural phenomenon, which was thought to include natural products. And then abstract ideas, which as early as late as the 70s, the court had a couple of decisions about how you couldn't let abstract ideas, as in algorithms, be patented because they weren't something that fell within the scope. Why? They don't fall within the scope of the statute because they would then let somebody preclude anybody else using such a law of nature or natural product or abstract idea, and that would in fact get in the way of invention because someone could actually hold on to that idea and prevent anybody else from doing it. In a case that had nothing to do with subject matter jurisdiction in the 60s, the court said that you couldn't patent a method of making steroid molecules because you didn't know what the steroid molecules that you made would do. And the idea was you didn't want somebody putting up a bar so that nobody else would be able to make steroid molecules. If you didn't deserve the patent, although it wasn't decided on these grounds, but the philosophy was the same. That you didn't deserve the patent because you would be essentially the gatekeeper and keeping everybody else in the field from working on it. So that's really what they're concerned with. Now, how do we get to where we are today? Well, the Federal Circuit was instituted in 1982 expressly. It was an idea that came up from the 70s. Patent law in America wasn't doing so well. We weren't protecting our inventions. Those of you old enough remember where we were all told that foreign countries were going to eclipse us because they were smarter and better. And no, it's the fact that we really weren't protecting what we were doing. So all of a sudden, you have patent protection, and it's not a coincidence that the biotechnology revolution and the computing revolution and the telecom revolution all happened in America because people could actually protect their inventions with patents. And so the reason that actually this worked was that the Federal Circuit was a special court. And we don't really have special courts in this country. We have bankruptcy court, not to be a downer, but we don't have very many other courts that are specialists. But the Federal Circuit was given a control for all appeals for all patenting matters. That means if people are unhappy with something the Patent Office did, not that that happens too often, they would go to the Federal Circuit and file an appeal. If people had a patent dispute between two parties in the district courts and one party won and the other lost, they would go to the Federal Circuit, the loser, to try to get the decision overturned. And that gave the Federal Circuit a great deal of influence on how U.S. patent law developed. And I will give the Supreme Court credit. They kind of left the court alone for about 25 or 30 years. Because if the Supreme Court had come and reversed every case that the Federal Circuit had, it wouldn't really satisfied its function of harmonizing U.S. patent law. Having said that, the Federal Circuit did, feeling its oats a little, Paul Clement, a former solicitor, said that there are all these Supreme Court decisions about patent law that in the modern age seem not to be particularly apt, that the Federal Circuit quietly walked away from. Well, they did that for 30 years, and the Supreme Court came back with a vengeance, and were sort of informed by academics, no offense, academics and political commentators that said, well, the Federal Circuit has run amok. You had the Federal Trade Commission, no friend of patents, who issued a report in the turn of the century. You had the National Academy of Sciences that did the same, mostly because of two things. One, the Human Genome Project, which got all of the National Academy people upset. And two, the fact that there was a decision at the end of the 20th century that said all of a sudden business methods could be patented. People thought that they couldn't, and so nobody applied for them. Well, in fact, the Federal Circuit said they can, and all of a sudden everybody applied for them. We were getting, Wells Fargo and American Express were knocking on the door to help us patent things. And this was thought to be an overreach. So you gradually had the Supreme Court step back, and every time they perceived that the Federal Circuit had come up with a special rule, they said, no, we have no special rules in American law. And they reversed. And pretty much when the Federal Circuit takes a case, they almost always reverse from the Federal Circuit because there's no other court. I mean, they're the only court of last resort. So the court has gotten involved with this, and one of the things that got to be a problem for the Supreme Court was this idea of going beyond the scope of the statute and contravening these three thou shalt nots that they had developed in the law. Having said that, there's countervailing law that gives us a certain amount of solace. One case called Deere, the only case I'll mention, that says you have to look at the claim of what the invention is as a whole. You can't pick it apart and say, well, this part's not patentable and this part's not patentable, and at the end of the day, nothing's patentable. And so one of the things that people are doing now, besides thinking about ways of amending 101, is they're thinking that if the courts would, not so much the Patent Office, because I think they do this, but if the courts would look at something, and I'll give you an example. The Sequenom case, which is I mentioned another one. The Sequenom case, the Crystal did it before me, so that's okay, is about a method for detecting paternal DNA, fetal paternal DNA in a pregnant mother's bloodstream. And what it is a substitute as a blood test for things like amniocentesis and chorionic villus sampling. And the problem is that the district court in California did exactly what I just said. They basically looked at the invention and said, well, this piece isn't patentable, and this piece isn't because it used PCR, which was a routine and conventional method. And at the end of the day, they got to the bottom of the pile and there was nothing left. That would have not been so horrible. It was one district court, except then the Federal Circuit took the case and they affirmed, but in a very interesting way. One of the judges wrote a concurring opinion that sounded like a dissent. And then when they had a further chance to look at it again, 4 other judges wrote essentially the same thing, and their bottom line is, our hands are tied. The way the Supreme Court wrote its decisions that Crystal talked about, the way that the language that are used and the way that the courts are interpreting them, there's nothing that the Federal Circuit thinks it can do. And that's why that case is important, because it's going up. The petition has been filed to ask the Supreme Court to look at it again. And so what we hope we'll do, and quite a few amicus briefs will be filed, and I'll do one of them, is that if the court looks at it, they have to understand that their job is to draw lines, and that's fine. But the lines that are being drawn, mostly by the district courts, a little bit by the Patent Office, but they're getting better. Those lines are too stringent, are too rigid, and are in fact doing exactly what the court doesn't want to happen. Not promote progress, impede progress. Because the reality is that today, when I get a request from Wharf or other universities about, okay, we have this new method, a diagnostic method to diagnose whatever it is, I realize two things. One is, this is always in a form that something is detected, and then by looking at what's detected, the observer then infers something. That somebody has a disease, somebody doesn't have enough vitamins, what have it, that there's paternal DNA and maternal blood, and it indicates there's some problem with the fetus. And those types of claims, the way that they're being interpreted today, are almost entirely patent ineligible. So I'm really left as an outside counsel to Wharf saying we have to delay. And I'll talk a little bit more about that when Michael gets into it. But because right now, there's no way that you're going to get that claim allowed, not because the Patent Office doesn't think it's patent eligible or doesn't want to, but I think the Supreme Court's tied all our hands.
Perfect. All right, we'll open it up to some questions, but I just want to pick up on that and ask you that first one. Okay, it's complicated. Even Kevin, who's super smart, is a little confused. It sounds like the Federal Circuit is disagreeing with each other. What do people do as a practical matter to approach this?
Delay. I mean, I really do think that there's a provision in U.S. law that you can file a provisional application today, right? And nothing happens to it unless you convert it within a year. So that's 12 months. And then at that date, you can file something called a PCT application, which just is an application filed under treaty that the U.S. has subscribed to, ceded to, technically, and that gives you another 18 months before you have to come to the United States. When you go into the United States as a national phase, what's called, you get at least another 14 months, and that's the canonical amount of time that the Patent Office has, and probably longer in Group 1600, the biotechnology arts. So now we're out around 4 years, and I'm hoping 4 years from now we have a little clarity. Okay, but that's the only real practical thing, because by filing that provisional application today, it's really a placeholder. Until 4 years from now, the Patent Office picks that up, and they're going to judge you by what the prior art was today. You know, what patents were there today. And so you really do get the benefit of having that flag in the sand, saying this is my invention, and hopefully in 4 years you get something. The one fly in the ointment is that if it isn't better by then, you will have disclosed to the world how to practice your invention. And at that point, one of the problems is for a lot of these diagnostic tests, people always say, well, you know, why do you do this? It's because I don't want big LabCorp, and that's a company, I don't mean them specifically, but big mega giant corporation, U.S. or foreign or domestic, to come in and steal your inventions, because that's what they'll do if you can't patent them, because why not, okay? And that's what happened in the 70s in America. And so, I mean, there were apocryphally people sitting, waiting for things like the PNAS and Cell and Science to come out, and they'd go through, and if there was anything that they thought they could commercialize, they would. Why? It was made in American University. Oh, too bad. They've given up there. They don't have any rights in this. And so I think that it's been beneficial, it's a whole different discussion, but it's been beneficial to protect the inventions that are made in universities. And so that's the conundrum that you have, because you can't keep it a secret. You have to disclose it, and I think you should.
So your advice is to delay. Your company might go bankrupt in the meantime, but that's another. No.
Because after all, the history of biotechnology is, you know, overpromising, under-delivering. I mean, there are companies that started in the '80s that never made a product that are still around. That's never a problem in biotechnology.
Crystal, did you want to add anything to the?
Yeah, just to clarify, and that he's saying, by saying delay, he doesn't mean delay, sit on it, do nothing. He means file.
Yeah.
So they'll be doing that. So we're in a first to file world now, not a first to invent. So we always tell people, file.
I wanted to just build on something Crystal said in her presentation before about looking at the PTO website, looking for the examples that are provided to the examiners. That really is instructive as you're trying to make these arguments. You can imagine if you were in the shoes of an examiner with all of these complicated changes in the law, you're very hungry when the guidance comes from the patent office and you review the slides and you're applying those on a day-to-day basis as you're interacting with applicants. And so they really follow those. And it's really useful as an applicant to understand that and then to speak in terms of what that guidance says. So it really is a roadmap that's very useful, and I'd really recommend it to people. And it's fairly easy to just follow the slides and the guidance, I think, online. That's something that an investigator could do.
I think we had a question. I saw a hand.
Yeah.
There is a way to keep it secret, though, if you're in certain fields where you can use trade secret law to your great benefit. So a local company just won a $940 million judgment this morning.
For a university, it's very hard to do that. I mean, that's not the university's role.
But the proposition is a dangerous one because you don't know the speed at which your application is going to be examined. And you've articulated this, right? At the end of the day, you're only going to get 18 months. You file your provisional, you file your PCT. They're going to publish it at 18
30 months. Oh, no, it's going to publish in 18 months. That's
It's going to be published in 18 months if you claim priority back to your provisional. So you bought your, and 18 months, maybe you get an answer, maybe you don't. But the danger I see in that is that if you've sunk a lot of money into that and the value is in the secret sauce, so in the pharmaceutical game, producing most of these compounds is chump change. Right? I mean, the whole value is in the years that went into identifying the national product, isolating the natural product, optimizing the natural product so it's no longer natural, right? At that point, then you're good. Then you file, right?
Exactly.
At that point, then you're good. But if it turns out that the natural product is the cat's meow, you've sunk a ton of money to get that natural product. That's a pretty big coin toss to hope that the Supreme Court falls on your side of the fence.
Well, the problem is what's the I mean, if you're going to be selling a pharmaceutical, you're not going to keep it a secret.
Well, no, but in other industries in the software game, there's no reason I have to divulge what's in the code. I set it up as a trade secret, and I rent the software, and I contractually obligate them not to reverse engineer my software.
That you could do. Yes, that you could do.
And just a little bit more about trade secret so for those of you who don't know trade secret, it sounds really simple, but it's not. It's basically you keep it a secret. That way you can keep it. You can't hear. So the problem with that is reverse engineering, even in the computer space. The other problem with that is trade secret is mainly a state-based law. So there are things you have to do in order for it to be considered to trigger trade secret. And even then, what do you do if someone misappropriates it? It's very challenging. What the Congress is doing right now is putting together a federal trade secret law that would make it a federal law. Think back to when trademarks they still are just statewide, and then we had a federal trademark to make it much easier to protect your trademarks. Same thing is in the pipe, in the chute for trade secrets. Trade secrets are very tricky, and I tell people about them all the time. So code, fine. As long as you're fine with someone reverse engineering it or finding out about it a different way or inventing it and going out and doing it, then maybe trade secrets for you.
We've got a question in the back and then Beth up front.
Hi. My question is for Kevin.
Yes.
Maybe it's just one question about idea. What's the first idea to build Wharf, and what's the core idea for Wharf? Because Wharf do not product things, but it is just a bridge to connect the university to the society. So what about the third thing? In the nowadays, everything changed. How does Wharf to keep going to service the society and the university?
Well, I think that I don't want to be too doom and gloom. I think it's difficult to get things patented, not everything. And I think you're right. WARF was one of the first groups where you had the facilitator role between the university that was coming up with inventions and investors and companies to try to actually commercialize them. I mean, I think the thing that people don't get about patents is that it's not really worth very much if it's not supporting sort of a product. It's not supporting something that you're doing. It's nice to have on the wall. It's a nice piece of paper, but it doesn't do anything unless it's supporting an industry by preventing other people from expropriating whatever it is you invented. And so I do think that WARF has a role and will continue to have a role doing that.
Can I have another quick comment on that? Is that people tend to forget the past. And before Bayh-Dole, there would be no one in this room because no one would care about patenting. Because mainly universities couldn't patent. And there was just too much uncertainty about who owned it. And now we have a room full of people who are concerned about patents. And the reason is because before, the universities were doing all this invention, but it was just sitting on the shelf. It wasn't getting from invention to commercialization. And the point of the change in the law was to have what you're inventing actually come to fruition to help the society. So Wharf is one of the leaders in that. And I'm not sure if I completely understood your question, but I don't think that's going to stop anytime soon.
Hope not. Yeah. Hey, Beth.
Former general counsel for Wharf and now the leader of a biotech company, a licensee from Wharf for the last 9 years. Kevin and I have been having some offline discussions about Sequenome. So where to begin? I'll try to make my comments brief, but I think this is really where the rubber meets the road. So we're trying to patent biomarkers associated with diagnosing autism. We're conducting the largest clinical study of the metabolism of children with autism ever conducted at 8 sites across the country, funded by NIMH and a private foundation. We're trying to patent these biomarkers. And they occur in nature, but were never known before. They're informative of subtypes of metabolism of kids with autism, which may also inform a way to intervene and change the outcome for these kids. We're getting 101 subject matter objections left and right. The Wharf cases are experiencing them nearly now to the final phase. We've elected to publish on the first of these, CMPF, which is a fatty acid with a furan ring. There are 5 additional subtypes we've elected to keep trade secret. And this is an enormous shame for science because people should be standing on the shoulders of the biology and the things that we're discovering to hurry and find a solution to the now 1 in 68 kids diagnosed with autism in our country. The one that we did publish on, we learned last week, our competitor, Stan Lapidus at SynaptDX, filed on it. The Patent Office actually issued it. And we have a prior provisional that we filed, so we have the earlier date. But we filed, of course, following the pathway that Kevin articulated, and so it hasn't been published yet. So now we have garbage in the Patent Office that has been issued that we have to rectify and deal with, which causes us expense. So I also want to add that while biotech companies can live forever, many don't, and we have had an extraordinarily difficult time raising money in the venture capital markets because of the uncertainty caused by this case law. We have found that it's encroaching now into other areas. So the other side of our business does compound safety screening using human embryonic stem cells and biomarkers we discovered that can predict whether a compound will cause birth defects. We're now getting Section 101 objections to cases that are still in progress. We have some that are already issued. Are they worth anything anymore? This is a question my investors want to know the answer to. So finally, I guess where I would like to see this come down is in the day, I can totally understand why we should not be allowed to just patent genes or metabolomic biomarkers without function. But where we have discovered a function that is useful and novel for diagnosing and potentially treating and curing people, we need to be able to patent that subject matter, or we will see an enormous decline in the innovation in our country, economic development, and jobs in the biotech sector. I'm living it every day, so it's absolutely true. And I guess I'll let you respond to my comments.
Yeah, so I'm gonna say this one thing really quickly. What you're saying is, as a policy matter, it makes sense to allow these things to be patentable. And that is not up to the PTO. It's really up to Congress to decide those things. The Supreme Court and the Court of Appeals for the Federal Circuit recently have been deciding those things. So I don't know that you get a lot of objections from anyone at the PTO that, in the case of sequinome, is where basically you have to put a needle in a pregnant woman's belly to get the amniotic fluid versus take some blood. I mean, who's going to argue that's a bad idea? We can't change that. The Federal Circuit has been very clear. It's very, very clear. What people are asking us to do is ignore the law. And one of the good things up until maybe 2 weeks from now, a week or two from now, is that we have not incorporated sequinome into our training for our examiners because it's not settled law yet. Unfortunately, as you know, you have to deal with the president of Mayo. And reading that on its face says that correlations don't work. So I have a lot of sympathy, but at the same time, you're asking us to break the law. So I don't know how you want me to answer that.
I guess my point is not directed at you specifically,
Right.
Patent Office. However, I will say that I think the examiners are taking a much more expansive read, and we're seeing it now all the time compared to what we saw even a year ago. And I actually heard a rumor that they're being scored if they miss a 101 objection. So I'd like to hear
Well, they're not missing many, I'll tell you. Well, I guess I'll give you 2 data points. One, I'm sorry if I delayed you doing that, but you do have an earlier priority date, so I hope we can work that out. But, okay, I think 2 things. One is that Nancy Link is a woman was used to be Solicitor General a long time ago, and she got up at Bio a couple of years ago and told, not that's your boss, but told the legal guy who was Drew, who was Hirschfeld, who was talking about this. She said, in her day, and she had enough white hair to be able to say that. In her day, the Patent Office felt it was their job to push back when the Supreme Court did something dumb. And she actually said that, which was great. And I think that the reason that resonated is that at one of the oral arguments, I think it was in Alice, an advocate said, well, as you said in Mayo, Justice Breyer, blah, blah, blah. And Justice Breyer said, I don't think I said that. And in fact, it's exactly what he said, okay? It's a generalist court. They're not always focused on the same things that patent lawyers and scientists are focused on. And I think they're trying to do the right thing. But Justice Breyer also said he thought their job was to paint the broad outlines and to let the lower courts and the Patent Office figure out the details. And my only criticism, and it's certainly not of you, but my only criticism of the office is this idea that we have to do it this way because the Supreme Court said. In the law, very rarely is there a black letter law coming out of the Supreme Court. Sometimes. But in this case, let's just say there were places where a properly motivated group, whether it's the courts or the Patent Office, could have distinguished the circumstance. For example, in the Mayo case, this was all stuff that had been done for years. Everything in that case, in the claim, had been done forever. It was just the correlation that they happened to find, and that was the only thing new in the claim. And so there are plenty of ways, I think, you can distinguish that from what Beth is talking about. And so I do think that, and I've said this to Beth before, but I'll say it to all of you, publish stuff. Get a lawyer to help you write a brief to tell the court what they're doing wrong. What they're getting are the people who think everything should be free. The data should be free. Medicine should be free. Everything, we should all kumbaya and run around with the butterflies and the daisies. People who don't have a clue how this is actually done, how Beth has to get her business to work so that it's validated and we know it's accurate and it isn't just something that came up in a lab. People actually have said to me, well, the federal government paid for that drug because it was an NIH grant, because they have no idea what it takes to go from an observation in the lab to actually a drug on the shelf in the pharmacy. Okay, and they don't want to have any idea because that would ruin their preconceptions and might make the pharma company, who are easy to demonize, might make you a little sympathetic of the billions of dollars they spend, and every once in a while they get a drug that actually makes money. So I think we have to help all of us in our writings and in telling the court, here's what you're doing. Believe me, if the Wall Street Journal had a headline, Supreme Court ruins biotech, they'd pay attention, okay? And that's what they don't get. They get, this or that scientist says, you shouldn't be able to patent genes because that inhibits research. I'll tell you something. When the BRCA genes were patented in 1997 to date, there are 15,000 scientific journal articles about the BRCA genes. Not one of them has ever been sued by Myriad. Why? Because that's not how it works. Nobody cares about scientists doing science. That's what they're supposed to do.
Kevin, can I just, I heard one thing in Beth's comments too, that about the kinds of rejections you're getting on 101. And I've heard others argue that, well, really they're obviousness objections, and we've somehow broadened the concept of 101, and that's the mistake
It's
made.
funny. Well, the thing that's really the scary thing is that if you look at the slide, and I don't remember it verbatim, but what Justice Breyer said is there has to be something inventive. The word inventive is something that came from prior to 1952, and Congress codified something called obviousness that made it, and the reason they did it was that they wanted to take out some of the subjectivity in whether or not something should be an invention. And so they had ways that whether something was obvious as opposed to being an invention was it had to depend on there being prior art that would have suggested to someone of ordinary skill in the art that in fact this would be something that would work. We had to put it in simple terms and get the legalese out of it. And it worked pretty well in terms of obviousness because the Supreme Court had all sorts of flash of genius and synergy and all these very subjective determinations of whether something was an invention, depending on whether it was inventive enough. Something very similar is happening here. And the problem, and I think it's illustrated by what Beth talked about, is that, I can't figure out how an examiner could let your competitor patent that, okay? And yet they did. Why? Not because they're a bad examiner, because it's subjective. I'm going to look at that prosecution history, though, and see what they did. But it's a subjective determination, yeah.
They did something very strange, and I'm still trying to figure out why, because it was just last week. They combined the small molecule that's of interest to us, alone or in combination with the others on the list, with an anti-fungicide, which, unless it's pervasive in every human, I would think that claim would not be very useful, because you have to have the fungicide plus one or more of these others, which includes
Right.
the biomarkers. Because in an attempt, I think, to create something that doesn't encourage
Right.
garbage.
Yeah.
Well, that's what PTAB is for.
Hey, maybe the Patent Office Full Employment Act, maybe.
Yeah, right. Yeah, the lawyers aren't complaining here. We have a question here.
Well, my question is related to the prior art. You remember that, now you got so much information. You got Facebook, you got blogs. So, for example, for PCR, the DuPont had challenged that patent that
And
there
they
was
lost.
one paragraph in one of the papers.
Yeah. It was, in fact, Gurban Khurana. In fact,
Yeah.
they asserted public something that Gurban Khurana had done or said in 1969 or something 70, and they challenged the PCR patent and they lost because it really wasn't. Again, that's why obviousness and the law of obviousness really helped, because in the past, if the Supreme Court had said, oh, well, Gurban Khurana, who's a world famous scientist, had said this in this paragraph, good enough for us. Okay, not an invention. And here, because you actually had someone, an examiner, well, actually a court in this case, but you had an expert say, look, yes, he had a glimmer of an inkling of something like this that could have happened, but it's very different from the claim that the Carrie Mullis came up with. And so I totally take your point, but that's how obviousness is the antithesis of subjectivity, because it really is based so fundamentally on what was in the art and how people appreciated it at the time.
So my question is that how extensive is your analysis when you are looking at the patent? Is it published literature or even a blog, or is it even a Facebook or a Twitter, or what do you?
Facebook's a good question.
Well, so there's a couple of questions within your question. The first is, you're probably not going to be doing the patent searching. I guess Wharf is going to be doing it for you. We have, the Midwest regional offices, all the regional offices have the same search terminals that our examiners use. So you can come in and do searches yourself to see what, using the same universe of materials that the patent examiners use, free of charge. So that is one option. You're asking, there's so many different things you can look at. How much do they look at? They only have a certain period of time to be able to look for things, so they're not going to look at everything within the universe. The additional problem that's come out since AIA, not problem, but policy decision, it's not just patented and printed materials worldwide. It is now everything that was known or used worldwide. So I have no idea what someone in East Timor knows. However, someone could come a couple of years from later and find out that actually was exactly what you did. So it's a much more challenging universe for people because there's a lot more prior art that is available. Our examiners can't possibly look at everything.
So if you had an abstract in Japanese or Chinese, you probably don't look at it, right?
We have mechanical translations, so it's very possible we do look at it. We also have what's called the global dossier. So it's the top 5 patent offices in the world that we could access their information. Actually, everyone in this room can access their information, the patent the files with machine translations. So yes, we do look at this, at those. I guess my answer to your question is, we look at a lot of things. We'll never be able to look at everything.
I think we're just about up for time. We've got drinks and hope people will join us for some conversation after this. I'd like to thank our panelists for their time and attention. It was a great talk.
Thank you.